Okay. Hi, this is Raina. I know that it probably comes up as saying that I am Ty Cinnavon. This is actually Raina Alexander. It's just how we log in sometimes. So I apologize if there's any confusion. Welcome. This is Standpoint's webinar, monthly webinar. This time we are here talking about Housing 101 and about landlord-tenant law. I will remind folks that this webinar is being recorded, so just keep that in mind. For folks who are unaware, Standpoint is a statewide organization here in Minnesota that provides legal advice and consultation to domestic and sexual violence victims, their advocates, the attorneys who represent them, and other professionals who work with them. I am Raina Alexander. I am the executive director, and I am the host of this lovely party. Normally, you guys are graced with Ty, but today it is me since Ty is off at the MINCASA conference. And so I will be making sure that Rachel and Amy stay in line. Your presenters
Good
today,
luck with that.
Yeah, I know. Your presenters today are Rachel Kohler and Amy Laricella, and they will be talking with you about Housing 101. They are both attorneys here at Standpoint. And I will again remind folks this is being recorded and will eventually end up on our YouTube channel. So if for some reason you're not able to completely watch this, or you see it and you think it's amazing and you want other members of your staff to see this, please feel free to let them know that it will be on our YouTube channel and will be available for free for folks to watch at a later time. And then I also want to remind people, if anybody has any questions, please feel free to send me your questions and I will interrupt Rachel and Amy as needed to be able to have their to be able to get those questions answered. So did I forget anything, Amy, Rachel?
You did a great job.
Thanks.
Good.
Yeah. All right. So I'm going to turn it over to Amy and Rachel. I don't know if they want to introduce themselves and take it away, ladies.
Will do. I guess I'll jump in first. I am Amy Laricella. I am, for those of you who have already started working with us, I am one of two Amy's that works at Standpoint. We have a staff of 5 attorneys and 2 of us are Amy. So, if you call and you think you hear my voice, you might just want to double check that you're asking for the right person, but we will definitely reroute you should it be necessary. My background is in employment and civil law. I have handled a number of tort issues throughout my time as well. And in light of the civil nature of a lot of these things that come up with housing, I am going to do my best to help support all of you lovely advocates in your housing needs. So that's a little bit about me. What about you, Rachel?
Oh, amazing. My name is Rachel Kohler. I am another staff attorney, one of the 5, the only Rachel, might I add. So if you need to speak to me, ask for Rachel. You'll get directed directly to me. My background is primarily in immigration law. I have a bit of a family law background as well, and I get to do some housing issues here at Standpoint. I don't have a whole lot more to say than that.
All right, let's get this show on the road.
All right, so our objectives today are first, Amy is going to cover the special housing rights and protections for domestic and sexual violence victims that is covered under Minnesota statute. Primarily talking about the right to terminate one's lease in cases of domestic and sexual violence. And then I'm going to jump in and talk about the special housing rights and protections for victims in specific subsidized housing covered under the Violence Against Women Act. We're going to talk a little bit about who is covered under the Violence Against Women Act and then how to invoke those rights and protections under VAWA. We're going to kind of bring it home with a couple of hypotheticals that use a lot of the information that we're hopefully teaching you about today. And as we have time, we will answer questions at the end, and obviously we'll ask Raina if there's any questions that come up throughout. But we did want to make note that, as you can see from our objectives panel, that we are not going to be addressing all of your rights as an applicant for housing or as a current tenant of housing. This is probably only the first of many different webinars we're going to do on housing rights. And this is specifically going to talk about the special protections in the Minnesota statute and those that are covered under the Violence Against Women Act. So we do ask that for the webinar today, you restrict your questions to those issues, but obviously as other housing issues come up in your work, you are more than welcome to contact Standpoint and we will help you at that time.
All right. So generally, just to provide kind of a quick overview for you all, as many of you are advocates and are very aware, there is a great overlap between the needs that a domestic and sexual violence victim have and housing. There, as Rachel said, are state and federal laws that provide protection specifically to survivors of those crimes. And ultimately, what they're really focusing on is they're recognizing that individuals should be able and free to live in their homes without the fear of violence. So the kinds of violence that we're going to be talking through with you today are domestic violence, sexual assault, dating violence, and stalking. And ultimately that in order to live a free and healthy life, you need to be free of those and access to stable housing. One of the things that I found very interesting as we were preparing for this webinar is just reading some of the commentary that's embedded in these laws. We're not going to get into it, but just know that there is a whole lot of thought and there was a whole lot of work that went into getting both the protections in the Minnesota statute as well as the protections in the Violence Against Women Act enacted as it related to housing. And you'll hear a little bit more today about why those things came about and why they're so important. So just kind of a brief overview, as many of you being advocates are aware, there is a huge, huge need for domestic violence victims in particular and sexual assault victims to get access to safe housing. There is a point in time count that happens every year that HUD does, the housing agency for the federal government. And in Minnesota in 2017, they conducted a point in time count in January 26th. So we're talking freezing cold, dead of winter, right? Depending on where you are in the state, it is 40 below. There were 7,668 people in the state that experienced homelessness on that date last year. And of those people, 2,216 of them listed domestic dating violence, sexual assault, and stalking as part of the reason they were homeless. That is a massive amount. So 29% of those Minnesotans were homeless due to this violence. And then something that our coalition, the Minnesota Coalition for Battered Women, did just this past year for the first time that we found really helpful to understand the scope of the problem is they tried to capture the number of people that were working with our programs who were trying to flee their violent situations, but were actually unable to access housing. And on that same date, January 26th of last year, there were 991 people who could not get shelter and had to either stay with their abuser. 578 of them did that. 57 of them stayed in the vehicle. And again, remember the temperature and the conditions in order to do that with your family. And 356 of them were staying with family or friends. So the scope of this problem is huge. This is something that is not, it's not unique to Minnesota. It is something that is happening all over our country. Housing is oftentimes the #1 need for domestic violence survivors. And so what we're gonna help you do is talk through these issues with you and equip you with information so you at least generally understand the rights that victims have as it relates to housing, and then flag a couple of things for you that you can certainly call us and we can help you walk through them at a later time. So, Minnesota law. What we're talking about with Minnesota law is a little bit more restricted than the protection that is afforded under the Violence Against Women Act under the federal law. It doesn't entitle you to housing in the same way as the Violence Against Women Act does, but it does and can protect your housing right and your ability to flee your abuser, I should say, under Minnesota law. So first and foremost, you have the right to call the police. Any tenant has the right to call the police or emergency personnel or make any kind of emergency phone call without fear of being evicted or terminated because of those calls. Landlords, of course, have heard and have counseled many people through those challenging conversations with landlords, as they oftentimes do not appreciate multiple police calls to the same location, but that absolutely cannot be the basis for a termination. And this last note here on the bottom, it doesn't matter if a city has a crime-free ordinance or anything. State law with this protection is going to override and trump the city ordinance in that case. So victims always have that right to contact emergency personnel and police if they need it. The number one call I think that we get here at Standpoint is, how do I move? How do I get away from my abuser and flee this situation when I have obligations already under a lease? So Minnesota law has codified protections to a victim that allow a victim of certain crimes, which we'll get into, to break that lease. These rights cannot be waived, even if it is written into a lease, which, believe me, I have seen those happen. That is not a valid waiver. So if you're counseling a survivor and he or she is nervous about a provision that's contained in that document, feel free to give us a call and we can talk you through it, but know that that right cannot be waived. So, as I've alluded to, a tenant can terminate a residential lease, a private lease, if he or she is a victim of domestic abuse, stalking, or criminal sexual conduct, and there is fear of imminent violence against either the victim or minor children if they remain on the leased premises. So this note here about co-tenants, oftentimes a survivor and the perpetrator might even be on the same lease, or there could be roommates involved. One thing to note is that if there are multiple parties on a lease, they do have the right to terminate the lease. The entire lease actually terminates after we walk through this whole process, and I'll explain to you how you go about doing it. But ultimately, that full lease for every single party on it is going to terminate at the end of that month, or whatever the interval is in which the rent is paid. And if that co-tenant would like to continue to reside on the premises, that is up to them to then negotiate and navigate a new lease with the landlord without the survivor present. One slight variation on this, there are certainly situations where a survivor wants to stay in her home, but needs to terminate the lease and try to move. It's something that she has the right to terminate the lease. She can do so following the processes that we're going to talk through in a minute. It would be up to her to talk through with the landlord why she feels it would be helpful for her to stay, why she feels safe still. Perhaps the co-tenant, her abuser, ends up being incarcerated. And so there's really she does not have any fear that he or anybody else that he knows that could be an extension of him would come back to that property. So she can certainly talk with the landlord. They have no obligation to renew a lease with her, but it at least is it's an option. It's something they can discuss. So how do we do it? First, we're going to talk with you about what kind of documentation is required. It can be any number of things. Minnesota law has a long list of things that qualify for documentation to support lease termination. So it could be a copy of an order for protection that is granted. It could be a copy of the domestic abuse no contact order. It could be just a signed document from a court official, or it could be a signed document from anybody in the city, county, state, or tribal law enforcement saying this person needs to break their lease. And we'll talk through what else it needs to say in just a minute. There also could be the option of having a statement from a qualified third party. This is where our domestic abuse advocates come in, or sexual assault advocates. You all qualify under our law as a third party in many instances, and we'll provide you with some examples about what that notice can look like, because you have every right to assist the survivors you're working with in preparing this document, writing the statement, and helping them to break their lease. In the handout section on the side, you'll see underneath on the right panel for our webinar, we've got a document. It's titled, sort of a little funny, but H23 Victim of DV Breaking Lease. That PDF there is a really, really helpful resource that was put together by our legal aid folks in Minnesota. It's available on Law Help MN, which you'll have this website at the end of our webinar in case you don't end up retaining a copy of this document. But ultimately, it it'll be just really, quick and easy reminders about what you have to do in order to break your lease. And if you flip to the very end, there is a model statement that can be prepared by a qualified third party, being a domestic abuse or sexual assault advocate, that will state to the landlord that this advocate has a reasonable basis to believe that their client is a victim of any one of those crimes, any number of them, and is in imminent fear that violence will be committed if they remain on the premises. So it's actually a fairly straightforward process, and you can use this handy dandy form, and hopefully that will assist you in helping your clients. So after that, once we've collected the documentation with our clients, we then need to inform the landlord in writing about our desire to break the lease. So you are going to note in the notice, which there's also a sample of in the back of this document that I'm talking about here, the notice to end the lease to the landlord. So you're going to note that the victim has imminent fear of violence, like it's happening right now for you or somebody living in your home. You need to terminate the lease. You need to note the specific date that you will be moving out. And then, if there's going to be other property that's left in the apartment or the house, instruct them in writing on how to deal with that property, and then attach a copy of whichever document it is that you selected from step 1 to support this notice. One thing that I think is important to keep in mind is once you provide that notice, whatever month it ends up happening in, if you provide that notice on, let's see, what month are we in? If you provide that notice on July 2nd, you as in the client is still going to end up being responsible for rent for the rest of that month. So it carries out through the full month, through the full, term of the lease, monthly term of the lease. And so it may be that the survivor decides it's more helpful to them to provide notice halfway through the month, and then they have a couple of weeks to still move out their stuff rather than having a whole month where they're probably not going to be living there. They have to make the decision that's right for them. But ultimately, whatever that specific date is that is designated as the date to move out, the survivor has to have everything that they need out of that apartment by that date. Otherwise, the landlord can charge them for another month on top of the one that they've already paid for. So it's just really important to pay attention to those dates. There's no designated time period or move out notice period in this context. There's no 30-day or 60-day notice as would otherwise apply under normal landlord-tenant law. So, they could provide notice on June 29th, and as long as they can be out of the apartment by June 30th, they would not have to pay for July rent. It all kind of just depends on the context and how quickly they need to move and what they need to do in order to get all of that in order. One last note about this written notice, it needs to be delivered before the lease termination date, of course, but either by mail, by fax, or by personal delivery. And, as I said, it has to be accompanied by a copy of that other document. We recommend that survivors keep copies of these written notices, as well as a copy of the way that they attempted to provide that notice to the landlord, just simply because it ends up helping them in the long run should the landlord try to fight it, though that would not be advisable in my opinion. So from there, step 3 is you pay your rent and you move. As we said already, you and any co-tenants, the survivor and any co-tenants still have to pay for the rent. They will unfortunately forfeit their security deposit. It's kind of one of the ways that the legislators, still are trying to balance the needs of a landlord in terms of notice and trying to rent the unit again. And so oftentimes the landlord will retain that security deposit. However, at that point in time, the survivor then has the ability to break their lease and not finish out the rest of the term, through no other penalty. One thing to remember is that if there are any delinquent or unpaid rents on the property that occurred prior to giving that notice, they are still on the hook, and any co-tenants are still on the hook for those payments. So that would still have to be dealt with. And to the extent that there are money orders or things are being paid with in cash, we also recommend trying to keep a copy of the receipt of the money order, or, a note about the fact that it was a cash payment, or a copy of the check, whatever it might be, just to, again, really protect the survivor and show that he or she complied with the law. And now a little bit about confidentiality, which we are all very familiar. In general, landlords really cannot disclose this information to anybody. They can't disclose any of the information that they learn or receive in that written notice or that they learn about in that qualifying document. If there's a new relocation address for the survivor that they're aware of, they cannot disclose that. They can't even disclose that the person has achieved the status of a victim in this context. So they really should not be talking to anybody about this. You know, there might end up being landlords who attempt to corroborate or talk with perpetrators. None of that is allowed under our Minnesota state law. The landlord can request identification of the perpetrator just so they know who it is. You know, if they're doing it as a means to protect other tenants in the building, if it's a multiple unit building, but the victim does not have to provide that name. If they feel safest just not disclosing who it is, you know, of course, if there are only two people on the lease and they are saying my co-tenant is the perpetrator, they certainly have the right to say that, but they don't have to. They don't have to say if it's their co-tenant, if it's their boyfriend who doesn't live with them, if it's their daughter's boyfriend. They don't have to say any of that. It should not prevent them from still being able to break their lease. So that's just a little quick rundown of what Minnesota law provides. Raina, have we gotten any questions on that before we turn it over to our federal protections?
We have not.
Solid.
Does anybody have any questions?
If you do, type them on in there. While you guys, I'm sure, are feverishly typing, it is now my turn. I was having such a nice time listening to you, Amy. Well done. I'm going to talk about the housing protections under the Violence Against Women Act. Before I launch into that, I do want to note that, and I'm sure this is, you know, preaching to the choir since I'm talking to a bunch of advocates, but the Violence Against Women Act does not just protect women, it protects both men and women equally, or anybody of any gender status. And I do want to note that the Violence Against Women Act is a federal law, and therefore these protections only apply to federally funded housing programs. You can go ahead and advance the presentation, Amy. Okay, so I'm gonna give you a little bit of a taste of things to come. I probably should have put the history of VAWA in the next slide, but the Violence Against Women Act was enacted in 1994, but the housing protections weren't added to the act until 2005. And the reason that they were added was really based on these congressional findings that were made in the reauthorization in 2005. They found extremely strong connections between domestic violence and homelessness. 44% of the cities surveyed in one report identified domestic violence as the primary cause of homelessness. And 92% of homeless women stated that they have experienced severe physical or sexual abuse at some point in their lives, 60% of which had been abused by the age of 12. There are also certain trends that they saw develop in their investigation, which indicated that there is strong discrimination based on status as victims of domestic violence. And of the legal service providers that were queried around the country, they connected evictions strongly with domestic violence crimes committed against the victim. So lastly, they found that victims were often returning to abusive partners because they frequently lack adequate emergency shelters. And so because of that, they're unable to find long-term housing and they may return to the abusive environment. The average stay, according to the 2005 congressional finding, the average stay at an emergency shelter is 60 days, while it typically takes 6 to 10 months for a homeless family to secure housing. So it's obvious that, you know, kind of as Amy was indicating in her point of time slide, that your options are limited. You can stay with friends, you can stay in your car, you can, you know, be homeless, or you can return to the abuser. And so because of that, lots of people will opt to return to abusive situations. And you can go to the next one. And this is just another way of showing what Congress found, that the violence and abuse can lead to homelessness, which can lead to poverty, which can lead people to returning to violent or abusive situations, which can lead to homelessness, which can lead to poverty, and so on. And so the point of adding the housing protection provisions to the Violence Against Women Act was really to address these congressional findings. You can go to the next one.
Oh my gosh, I keep trying. I don't know why my computer freezes a little bit every time.
Oh,
I'll keep
that's
working on
all
it.
right. I'll just keep
Yeah.
telling you, next, please, next slide. And so in the 2005 reauthorization, they also listed all of these congressional purposes. And so the first purpose that they listed was that protecting the safety, that the reason that this is these provisions are included in VAWA is to protect the safety of victims by ensuring that victims have meaningful access to the criminal justice system while not jeopardizing their public housing. They also wanted to create long-term housing solutions to help develop community and provide sustainable living solutions to victims. They wanted to build collaborations among service providers to provide appropriate services and trainings to address the needs of victims. And lastly, they wanted to enable public and assisted housing agencies to respond appropriately to domestic violence, dating violence, sexual assault, and stalking, while maintaining a safe environment for all housing residents. And then, as I was telling you earlier, Amy, I did, just the pride in me wanted to put this particular public housing apartment complex up on here because it's just down the street from us. And I've actually toured the facilities and they're really, really nice.
They're beautiful.
They're beautiful.
There we go.
You anticipated the next slide.
I knew it was coming.
Okay, so as I kind of spoiled a little earlier, I'm going to talk about the history very, very briefly. The Violence Against Women Act was signed into law as part of the Violent Crime and Control and Law Enforcement Act of 1994. VAWA has to be reauthorized every so often. And so in 2005, during the reauthorization process was when they included those new housing provisions. And I explained to you all of the congressional findings and purposes and the reasons why they felt it was important to include those provisions in the 2005 Violence Against Women Act. And then in 2013, it was reauthorized again, and it extended the housing protections to other HUD programs. It also added, like, as Amy was saying, Violence Against Women Act protects domestic violence, dating violence, stalking, and then they added sexual assault in the 2013 reauthorization. They added certain notice requirements for public housing authorities and owners. They added some information about emergency transfers. They added they maintained the 2005 safeguards, but they added new protections in the 2013 reauthorization. So everything we're talking about today, or everything I'm talking about today, is under the 2013 reauthorization. So the thesis of my VAWA part of the presentation is that applicants cannot be denied assistance and tenants cannot have assistance terminated or be evicted under a covered housing program on the basis of or as a direct result of the fact that they are a victim of a VAWA crime, which includes domestic and sexual violence, dating violence, and stalking. And in a little bit, Amy is actually going to define what we mean by domestic violence, sexual violence, dating violence, and stalking. I also wanted to note before Amy takes over that even though the Violence Against Women Act provides all of these awesome protections, there are other non-discrimination protections that exist for domestic and sexual violence victims in the housing context. Under the Fair Housing Act's anti-discrimination policy, you still can't be discriminated against for immutable characteristics or protected characteristics such as race, color, religion, sex, disability. And the HUD programs also have to abide by the equal access rule. So even if you have a client who may not be able to receive protections under the Violence Against Women Act, there may be other non-discrimination protections that can protect them.
Okay, here we go. So before I get into who is protected, I think we're just going to cover very briefly just the kinds of housing opportunities that we're talking about, the kinds of programs. So kind of the most common ones, the main three that we see are public housing, Section 8 housing choice vouchers, and project-based Section 8 subsidized housing. So think one of the only things that really is necessary for us to point out here is, you can read through these slides on your own time, but ultimately, if we're talking about public housing, that subsidy that the government provides stays with the unit. But if we're talking about Section 8 housing that the victim qualifies for, when that tenant moves, that subsidy will go with her and allows her to port her voucher. When it comes to project-based Section 8 subsidized housing, that subsidy stays with the unit. So there are some things to think about in terms of if you're counseling a client that does qualify and fall under one of these programs, just thinking through what that actually means if he or she needs to move.
Great.
And then just a very long laundry list. Now this is updated as of 2013, so this includes all of the various programs that are covered under the 2013 reauthorization. I'm not going to get into all of them. I also don't know that that's fully necessary for us to cover today, but just know that these are all of the programs. Feel free to refer back to this slide or find it on YouTube, or just call us if you have a question and you're like, oh, I don't know if this kind of housing really is covered by VAWA protection. We can help you navigate that. So who is protected by VAWA? What we're talking about are applicants, as Rachel suggested, so people that are applying to get into these kinds of housing programs, current tenants of those programs. So, one person will have 2 points in time where they are protected, right? When they're first applying, and then once they become a tenant, throughout their tenancy. And what that means is either the victim or an immediate family member of the victim, which includes any person living with the victim, related to him or her by blood or marriage, a spouse, a parent, brother, sister, child, and any other person who the victim stands in loco parentis with. And then the other component of this is an affiliated individual could also qualify and allow an applicant or a tenant to access VAWA protection, and that would be a spouse, parent, brother or sister or child of the individual, or an individual to whom that individual stands in loco parentis. Again, this is all very technical and legal. Call us if you're curious about whether you think somebody qualifies. We can walk through with you who would be that person. So the kinds of violence that a survivor has to experience in order to qualify, we've got domestic violence, which is felony or misdemeanor crime under the federal law, what it'll protect and what will qualify, by a current or former spouse, somebody with whom the victim has a child with, somebody who lives with the victim as a spouse. And then, because Minnesota law is broader than federal law in this context, any other adult person who is protected, who would qualify. So like under our law, Minnesota statute 518B will qualify roommates. So if you live together, but you're not intimate and you're not partners or a spouse, there still could be protection that would be extended in those kinds of situations. Oops, and I'm frozen again. Hold on. There we are. Whoops, no, there we go. So dating violence also qualifies. Violence that's committed by somebody who's been in a romantic or an intimate relationship with that victim. They don't have to be living together in order for that to apply. And when considering whether that relationship exists, folks are going to look at the length of the relationship, the type of the relationship, and how frequent those interactions were, how intimate was it. If you have questions about whether a very new relationship might qualify, you can certainly call us and we can talk you through that and help position you and the survivor in a way that would signify to housing authority that this person should qualify and has experienced dating violence. Sexual assault. So this is one that was just recently added. It was not initially covered under the first housing protections in VAWA. But after congressional findings and some public commentary found that sexual assaults oftentimes do contribute quite a lot to folks not feeling safe in their home, needing to move, and so it's been added. So under federal law, we're talking about any non-consensual sexual act, and that can include when a victim lacks capacity to consent. In Minnesota, it's kind of the equivalent. It's basically what we call crim sexual conduct. And then stalking. So even if there is a situation that you're working with the survivor on where it doesn't quite qualify as domestic or dating violence, wouldn't be sexual assault, but oftentimes there still may be an avenue to argue that the victim has suffered stalking. And what we mean by that under federal law is to follow, pursue, or repeatedly commit acts with the intent to kill, injure, harass, or intimidate. So that's very broad. And we can assist you in talking through what, if certain behaviors might actually qualify under that. It involves surveillance, there might be intimidation, any of those kinds of acts where they are a course of conduct acts that place somebody in fear of death or bodily injury, serious bodily injury, or substantial emotional harm or abuse, that could likely qualify as stalking. So with that,
I'm
turn it back
back.
over to Rachel. There you go.
Awesome. So again, to review, the housing protections under VAWA state that applicants cannot be denied assistance, tenants cannot have assistance terminated under the housing programs that Amy had enumerated a little bit on a couple slides ago, on the basis of or as a direct result of the fact that they are a victim of a VAWA crime, which includes domestic sexual violence, dating violence, and stalking. I kind of wanted to go through a couple of examples as to what we mean about on the basis of or as a direct result of the fact that they are a victim of these crimes, or the fact that it has to be a direct result of that abuser or that perpetrator's actions. And so I think that a lot of people may think, well, damage to the home, or if a crime was committed within. Those are sort of the examples I think of when I'm thinking of what would make me eligible for VAWA protections, but it can be seen broader than that. So I wanted to go through a couple of examples. Go ahead. Oh, you got it.
I'm on it.
So the first one I wanted to go through was if the survivor has poor credit history. And I listed out a variety of different ways that an abuser or a perpetrator might be the cause of that. If the abuser forces the victim or the survivor to get credit, but then the perpetrator is the one who uses it and doesn't pay for it. Or if the victim's credit or debit card is taken without their permission or by force, and again, perpetrator isn't paying for it, the victim is left with that poor credit history. If they have a joint account together and the abuser is running up debt, if they put the victim's names on bills and then the perpetrator doesn't pay those bills, or if the survivor lost their job due to the discrimination from victimization. I also, when I was thinking about the poor credit history, have worked with a client who, because of the violence she had suffered, she had some high hospital bills that she had to pay back. And when the hospital bills would be delivered to their home, the abuser would hide them. And so she was driving around one day and reached underneath the seat in her car and noticed that there was a bunch of papers that had been stuffed down there. And she saw that they were all the hospital bills that she wasn't getting and had a lot of late fees attached to it now. And now the amount that she would have to pay was significantly higher, obviously hurting her credit history in the process.
Yeah, and I think it's important to point out, just again, coming from the employment attorney side, so that job loss, it doesn't have to be that the abuse happened at the job, and so they then lost their job because of that, right? I mean, so what this oftentimes looks like is survivor is being harassed at work by perpetrator, or he's showing up at work, or she's missing work because of it. There could be any number of ways that being a victim of domestic violence or sexual violence impacts somebody's employment. And so should there be that job loss, whether it's because their supervisor is like, I don't want the drama of a victim in my office, get out, awesome supervisor. I've actually heard that before, by the way. There can be very long-term ramifications of that. So it doesn't even have had to have been in the past, 6 months, right? Like this could be something that was very ongoing. So just give us a call if you're concerned about any of these things, and we can talk through it with you. Also, foreshadowing, I will be putting on a webinar later this year that goes into more of the employment rights and protections that survivors of domestic and sexual violence might happen. So next time.
Great. Thank you. So this is the one that people might have been initially thinking about when they were thinking about VAWA protections, is like a poor rental history. If there is property damage due to domestic violence, if there are noise complaints, or the abuser was harassing or trespassing on their property, if criminal activity occurred therein, and I'm actually going to talk about even if the survivor or the victim has a criminal history or a criminal record, that might be covered as a VAWA protection. If they are missing or late on their utility or rental payments, or if they need to get the heck out of there, and their lease isn't ending for a while, but they need to get out, there might be early lease terminations, which would cause a poor rental history. There might also be a variety of different reasons why they failed to pay rent that is directly related to the violence that they've suffered, including injury, on being unable to obtain or keep their jobs, or if they are having a job and they're getting paid, but the abuser is taking that money and isn't allowing the victim to use that to pay rent. And then lastly, like I was saying, this is just a list of, and certainly not the entire list of different crimes that the survivor themselves might be convicted of or charged with that is yet directly related to the violence that they've suffered. And we've been doing a lot of work in human trafficking, and I can say that's it's pretty common that they might have a criminal record that is tied directly to that human trafficking.
So Rachel, what does one do if they want to avail themselves of their VAWA protections?
Well, let me tell you, I got a step-by-step process here. First, hard to fix a problem without a problem. So the public housing authority or the owner or housing manager must have turned you down, terminated you, or evicted you as a result of those abusers' actions, which can include all of the things I talked about on the last 4 slides, plus. So I wanted to note that in the 2013 reauthorization, there were certain requirements around providing notice of VAWA housing rights. And these rights must be notified of these rights in the following situations: when an application denial has been given, when a lease has been executed, in a public housing authority situation, if the Section 8 public benefit housing or the Section 8 voucher lease has been signed, in a Section 8 voucher program, if you've had contracts with individual owners that aren't necessarily part of the public housing authority, or in project-based Section 8 contracts, or in lease termination notices. So they have to provide a variety of different situations. They have to provide the tenant or the applicant with their VAWA housing rights.
Oh, and one other thing just to note going forward for everybody on the PowerPoint, we're going to use PHA rather than typing out Public Housing Authority every time, just because it's less to look at and more fun.
Right. So
there we go.
Direct connection. Okay, so let's say you have been denied, you have been terminated, you have been evicted from one of the enumerated federally funded programs. What do you do? So you need to then inform the public housing authority or the owner that you are a victim of one of those enumerated crimes, which we've already talked about and defined. I also want to note that the public housing authority or the owner might just, if you say I am a victim of domestic violence, you explain to them the situation, they might provide you with those protections and benefits based solely on that individual's verbal statement. They might not ask for any kind of documentation to back up that claim. But the public housing authority and the owner does have the right to request the tenant or the applicant to document their claim of abuse. So how do you do that?
How do you do that?
I'll tell you. So if they are wanting documentation to document the claim of abuse, you need to be able to provide enough information for the public housing authority or the owner to make that determination as to whether or not the reason that they're terminating, the reason that they're evicting you, the reason they're not allowing you to apply for this is a direct result of domestic violence, dating violence, sexual assault, or stalking. So the next slide is going to go through the various forms of acceptable evidence that the public housing authority or owner needs to accept. The first one listed there is the Housing and Urban Development 5382 form. That is included again on the handouts tab. If you click on HUD 5382, you can see the form that I'm talking about. It's a really easy form. The first page is kind of just more information about what your rights are, what this form is used for, a little bit of reminder of your confidentiality protections. And then the second page is just asking for the date that you're asking for protection, the date you're asking for certification, the victim's name. If someone else is applying for them, a third party can file a 5382 form on behalf of a victim or survivor. And then naming the accuser or naming the accused perpetrator, their relationship, the location it happened, the date it happened, just kind of basic information about what happened that they're claiming was the adverse action that caused them to get public housing removed from them. So that's an option, or they could get a document that has to fit these 3 enumerated requirements. It has to be signed by a professional, which includes an employee, agent, or volunteer of a victim service provider, which would include all of you fine folks listening on this webinar that are domestic and sexual violence advocates, attorneys, or medical and mental health providers. It also has to be signed by the applicant or the tenant, and it has to specify under penalty of perjury that the professional believes that the tenant or applicant would qualify for the VAWA protection. Thirdly, they could submit a police report or a court document, and then at the discretion of the housing provider, they may accept other evidence. Typically, if the housing provider is going to accept other kinds of evidence at their discretion, they should probably list that in their policies. Otherwise, the HUD 5283 or 5382 form, the document signed by the professional and the applicant or tenant, and the police report and court document are pieces of evidence that the public housing authority or the owner has to accept. They can't look at the 5382 form and tell you that, really, I would have rather have had a police report. You need to give me the police report. They have to accept any one of those top 3 kinds of evidence. Whether or not that evidence is sufficient to make them believe that the adverse factor they're claiming was a direct result of that violence is another question, but they do have to accept those top 3 forms of evidence. And it's also really important that, nope, you can go ahead, Amy. It's really important that we are mindful of the timeline around these things, and this is where you as advocates can really be helpful in making sure that the survivor understands that they need to get this documentation in fast. If the public housing authority or the owner is requesting documentation, they have 14 days, so 2 weeks to provide that to them. It can be extended based on certain factors. So this could include if the survivor is hospitalized, if they're in an emergency shelter and can't gain access to those documents, if there's delays in obtaining the police reports, or if getting the evidence could cause further violence. Those may be reasons why that timeline can be extended. During that 14 days that the tenant or applicant is getting the documentation, the public housing authority and owner cannot take adverse action during that time. But if the tenant fails to provide documentation within that time frame, then adverse action can be taken against them. So 15 days later, if they want to evict them, they can go forward with that eviction. Even if they're unable to get documentation in time within the 14 days, I still want to make sure everybody understands that they still can assert VAWA protections later in the process. It doesn't take their ability to assert VAWA protections away, but it does kind of take that safe period where where the adverse action can't be taken away from them, and they can actually be evicted or terminated at that time. In the very, very rare circumstances where there would be conflicting requests for certification, so if the survivor and the perpetrator are both requesting from the public housing authority or the owner that they receive VAWA certification, only at that time can the public housing authority or owner require third-party documentation. So outside of there being conflicting requests for certification, they have to accept either that HUD form, the document signed by the professional, or the police report. And what I mean by third-party documentation is anything that doesn't come from the survivor. So police reports and court documents would be considered third-party documentation, or surveillance videos would be considered third-party documentation. And if they have these conflicting certifications or requiring that third-party documentation, they have to give the tenants 30 days to provide that to them. So it's a little bit longer period of time, and obviously during that time, similarly, no adverse action can be taken. All right. And then obviously the last step in the process is that the public housing authority or the owner has to notify the tenant whether or not they found their denial, termination, or eviction to be on the basis of or as a direct result of being a victim of violence. And so at that point in time, they can choose to appeal that determination, and depending on the type of housing program they're in, depending on the jurisdiction they're in, the way in which they would go about appealing might be different. So we're not going to talk so much about that today. But I also want to note that the process I'm talking about, this 4-step process, is kind of an informal advocacy way of invoking your VAWA rights. You can also raise VAWA as an eviction defense during an eviction process, or you could file an administrative complaint with HUD asserting your VAWA rights. But there's a 1-year statute of limitations for that. So this is, I would say, for advocacy, this is probably the most common way that you're going to be assisting clients in invoking VAWA protections, but there are other ways that you can invoke it beyond the 4 steps that I'm talking about today.
I think it's also important just to put this in front of you guys, just so you have this information and we can help you navigate it should it come to this point. But as Rachel mentioned, each public housing authority is going to have their own, internal and then oversight process of what happens with these determinations if there's that appeal. Once a survivor has exhausted that process within that public housing authority, it's good to know that really the only other avenue of recourse they have is actually appealing it appealing it to the Court of Appeals. And I could be wrong about this, but I believe last time I checked, that's typically a 60-day period or so. So just know that there are, obviously if somebody's dealing with a housing issue, this is already going to be an exigent circumstance, but just know that there are limitations on how long you have to appeal those decisions. So let us know and we'll help out how we can.
Well, and at that point in time, going through these first 4 steps, I mean, you can do it without the assistance of an attorney, but at the stage in which I think if you get an adverse determination, you're probably going to want to seek assistance from legal aid or from a private attorney in order to be able to appeal that, because it's going to get a lot more difficult.
Yep, and we're certainly willing to help connect folks to attorneys to the best extent we can. Just know that most of the legal aid services, I believe maybe even almost all of them, Raina, correct me if I'm wrong, but do some level of housing support. So, Minnesota Legal Aid, CMLS, a lot of those will be able to, or hopefully be able to intake and assist your clients if that's necessary.
Great. Okay, so just to kind of cap this off, I do want to remind folks that even though there are these great protections for domestic and sexual violence victims, this does not mean that they can't be evicted or have their voucher terminated or, their lease terminated for violations unrelated to the violence. So they may be experiencing violence in the home, but the reason that they're being terminated or evicted for a lease violation may have nothing to do with that. And the victims aren't held to a higher standard than non-victims. They're all held to the same standard. And also, landlords may, even if you do qualify for VAWA protections, if the landlord can prove that keeping the victim in the unit would pose a, quote, actual and imminent threat to others, which means a danger that is real, a physical danger that is real, would occur within an immediate time frame and could result in death or serious bodily harm. They can still evict that victim if they can prove that. But the HUD regulations make it very clear, and they remind providers that evicting someone based on that actual or imminent threat should be a last resort. And really, the landlord should be trying to take other actions first, such as providing the survivor with a transfer, banning the abuser from the property, increasing police presence on the property, or other legal remedies that can keep the victim and other tenants in the unit safe. So it should be a last resort and something that they have to prove that there is actual and imminent threat before they can evict the victim.
All right, confidentiality again, all. You know, similarly to the Minnesota statute, there are confidentiality provisions in the Violence Against Women Act, as well as other federal laws that would apply. You know, for your purposes, I think what's important to note is that these are really strong confidentiality provisions. And you know, it makes sense that they would be. When it comes to federally funded housing, there's a lot of tracking and documenting and databases. And, you know, I don't have to tell all of you as advocates, there's just a lot that goes into ensuring that those providers are doing what they need to be doing under their laws. And ultimately, what VAWA does is it prohibits any of this information, any of the documentation, status as a victim, the similar information as to the Minnesota confidentiality provisions. It prohibits it from being entered even into any of the databases where that information is typically captured. You know, any personally identifying information about the victim, any of that cannot go in there. So, you know, there is a HMIS is the name of it, the Homeless Management Information Systems. It's the way that they typically track this. This information and related to a victim status and the reasons for why he or she is a victim under VAWA cannot go in there. If you have concerns that there has been a disclosure of that information, definitely give us a call, because at no point should that be happening.
Great.
So what's next?
Well, some common questions that may come up under VAWA protections is, what if you are in this federally funded public housing and the abuser is there with you and you need to get the abuser out of the home? There is a process for that called the lease bifurcation, which means they can remove a household member from the lease. So they can remove that abuser's name from the lease, allowing the victim or survivor to keep their name on the lease and to hopefully retain those public benefits. However, if the remaining tenant, so if the survivor isn't on the rental assistance, so say that's the abuser is the one who is actually receiving the public assistance, the tenant would then have 90 days to either establish eligibility for the same housing program or establish their eligibility for a different housing program. If they're not eligible for either, they have 90 days to then find alternative housing. And oftentimes, if the tenant is under a public assistance program with the abuser and the abuser leaves, that tenant would still likely be eligible for the housing program because their income would likely decrease since they're no longer getting the abuser's income. I also want to note that the landlord has to follow federal, state, and local laws in evicting the abuser. So even if there is a lease bifurcation and the abuser's name is taken off, the landlord has to go through the legal steps to have that abuser removed from the household. And the reason that I think it's really important to remember this, especially as domestic and sexual violence advocates, is that you should carefully safety plan with your client around the decision to request lease bifurcation, because, you know, through the eviction process, even if they're able to get an emergency eviction, it's not an immediate action. It's a process that takes time. And so in that interim time, while the abuser is being evicted, it's important that we make sure that the survivor is safe during that time. So another common question is, what if instead of, you know, getting the abuser off the lease, what if the survivor needs to move in order to escape that abuse? You know, the abuser can't know where they live anymore. This process would be called an emergency transfer. There are both internal emergency transfers, which is just requesting a transfer from their current unit to another unit within the property when a safe unit is available. You don't have to go through a new application process for the federally funded housing. However, if you are requesting an external emergency transfer, which would allow an eligible tenant to request a transfer to another unit in another property, they would be categorized as a new applicant and would have to undergo a new application process. So in order to request an emergency transfer, you have to ask for the transfer, and then you have to explain that you either believe there is a risk of imminent harm or that the tenant or household member was a victim of sexual assault on the premises within 90 days of the transfer request. All housing authorities and agencies have to develop a model transfer plan. They have to now if they're receiving HUD funding. And so if you're wondering what your particular client's housing or a particular housing agency's program is, they should be able to provide you with their transfer plan. And then similar to what Amy was talking about around confidentiality issues, all confidentiality measures cover the transfer. So this would help to ensure that the abuser does not know where they are going. This emergency transfer process is important, I think, because as Amy was describing before when she was going over all the enumerated programs that are covered under VAWA, most programs aren't portable, meaning most programs can't go with you. Most public housing programs are tied to that particular unit. So under VAWA, in allowing these emergency transfers, it allows you to port your public housing benefit to another unit or even to an external unit if you believe there is that risk of imminent harm or you've had that sexual assault within 90 days.
And yeah, just to dig into that a little bit further. So the Section 8 voucher is eligible and portable. You know, one thing that I do want to note, because oftentimes all of you lovely folks are working with individuals who might be in shelter temporarily. You know, this is something that you need to act on in a timely manner. And, you know, once you've ported your voucher, you got to get into that property within a reasonable amount of time, because it is something that, unfortunately, we've been in a situation where we have had to counsel some survivors who have just lost their voucher and are not able to then get into the unit that they're wanting to. So just something to keep in mind, that, you know, if you're working with folks who are in shelter, really help them and assist them in getting into their unit once it's available. So just know that, you know, a family that has a voucher can move to that other jurisdiction if it's under the Section 8 housing, if they've complied with all of their other obligations of the program and it's necessary to protect the safety of the victims, even if moving would otherwise be that lease or program violation. The Public Housing Authority may ask for that same documentation that Rachel was noting earlier. It can be provided and it should be honored. Now, in a situation where a family is breaking up because of domestic or sexual violence, the Public Housing Authority has an obligation under the law to ensure that the victim is the one who retains that voucher. So the perpetrator would have to then go through the process of applying for his or her voucher separately, and, you know, would have to meet all of those eligibility requirements in order to apply and obtain it, whereas the victim should be retaining it. So just things to think about as, you know, their victims are fleeing and trying to port their vouchers. You know, a landlord might still think that a tenant is on the hook for the length of the thing that they've signed or the program, but ultimately, if it does end up in eviction or conciliation court, being a victim and attempting to appropriately port your voucher is enough for a victim to succeed in that action.
All right,
so
let's do some hypotheticals.
Without further ado, here we go.
Everybody's favorite.
I know. What does this mean in practice?
Hey, you guys, do we want to do questions? Because there are a bunch of them.
Oh, look at that.
Such a good point. Thank you for jumping in, Raina.
Yeah, I was thinking I'd wait till you guys kind of covered everything, and then we would do questions.
And hit us
We're
with
all
it. Let's
ears.
go.
Before we get to hypotheticals. So, okay. What if a victim wants to stay in their home, but they want the landlord to change their locks so they can feel safe? Does the landlord have to do this, change the locks? And B, does the landlord have to do it free of charge?
I mean, maybe you have a better idea than I do, Raina, but I do know there are other states with lock change laws, but I do not believe Minnesota is one of those states.
Right. Yeah, Minnesota does not have an explicit law on this. There are definitely jurisdictions that do, and that even go down to figuring out that it's either the tenant or the landlord's obligation to pay it. We don't have any such protection. So just typical landlord-tenant law is going to apply in this situation. This does come up a fair amount, and so what we've done in the past is counseled the survivor to really have that frank discussion with the landlord, provide, you know, if there's an order for protection or something that's keeping him from the home, you know, provide some information to the extent he or she is comfortable with that, and really just try to appeal to the landlord's, you know, sense of decency in making sure that gets handled, because it is also in the landlord's best interest to keep that individual out of the home, so long as it is a legal action for that landlord to take. You know, it helps, instead of a survivor, often, and advocacy, when you're helping survivors craft these talking points, it helps to speak to landlords in a way that they obviously, you know, where their interests are upfront. And that sometimes can go far. Do you have other thoughts, Raina?
Yeah, I mean, arguably, not changing the locks could be a violation of the covenant of habitability, which we didn't get into the minutia about. There are these covenants that landlords have to abide by. And that could lead, I mean, then somebody could say that their place is not habitable and withhold rent. And there's a process for doing that, which again, we didn't get into here. Have I seen anybody do that? No. And so I have zero idea on whether it would be successful. It seems like it's a good idea. Whether or not the landlord has to pay for it, again, we don't have any statutory authority that says the landlord has to. So arguably the landlord could say no. I will remind programs that you have your own emergency funds and client services funds that can clearly be used for this purpose. Also the emergency funds through Day One or Cornerstone, whoever holds those, I can't remember which one, but they can also, those funds could be used to change locks, and depending on the circumstances, they may be able to use not reparations, but restitution to also pay for those they might be able to use reparations to pay for those locks. So there's a couple of different ways that it could get paid for if the victim's not able to, but those are kind of the arguments, but a lot of it is talking to the landlord and saying, you know what, blood is really hard to clean out of the carpets, so it's better to just do it.
Well, and to have a domestic or sexual violence advocate maybe writing their own letter or backing the survivor up with the landlord and explaining to them that it is not safe for, you know, the locks to remain as they are. So really to appeal to the landlord's sense of decency.
Okay. Next question. Why are only HUD programs covered under VAWA protection and not all victims of domestic violence, sexual violence, and stalking?
I mean, I would say because Violence Against Women Act is a federal law, so it only covers those federally funded housing programs for that reason. So, you know, states could pass their own protections in regards to their own public housing programs. But because it's a federal law, it's only applying to those federal programs. I don't know if that's a great answer.
No, that is the answer.
Okay, yes.
I mean, I think it's worth pointing out that there are probably, I think, almost 10 or so states that do actually afford being a victim of domestic or sexual violence a special status under their laws. And so it would extend protection under employment laws. It would extend protection under housing. You know, there are any number of things that would actually mean. Unfortunately, Minnesota is not one of those states, but there is a movement where this is happening on a national basis. And who knows, maybe we'll have the opportunity in the next few years to push something like that through.
Right. So obviously, you know, because it's a federal law, they can't tell. I mean, you can't tell just like Joe Schmo down the street necessarily what they can do because they're not being funded by the federal government. They're doing their own thing. And so I would say that's the reason.
All right, next question. What if the landlord doesn't want to rent to a person in the first place because of their history of domestic violence? Is that discrimination and you can take it up with the housing authority?
I mean, nope, sorry, go ahead, Amy.
No, that's okay.
So I had an intake of breath. I want to give you your opportunity.
I appreciate that. If we're talking about just, you know, private, not federally funded housing, unfortunately, right now, Minnesota does not have any protection for special protection for those survivors. You know, we certainly have seen folks try to make the argument that because sexual violence and domestic violence are oftentimes on the basis of gender and are happening more often to certain genders, that you can make those kinds of non-discrimination arguments, but they are much tougher. And, you know, oftentimes if it's because somebody's looking for housing, it takes a long time to really navigate the legal process on that one. So, you know, if we're talking about private housing, unfortunately, no, you don't have any right to housing because of that status, but you can certainly get out of your lease because of that status.
I would also add that as it relates to, can you take that if you have Section 8 housing, and like a voucher housing, and the landlord is refusing to rent you because of your history of domestic violence, you could definitely try to certify as a domestic violence victim and link that in that circumstance. Like, they're not allowed to hold a domestic violence victim to a different standard than anybody else. Right. So if the landlord is specifically saying, I'm not going to rent to you because you're a domestic violence victim, then I think that you should have a pretty solid argument to be able to get placement as it relates to federally funded housing. I also just had a conversation with an advocate where she was being denied because of damage that had happened, and so then the question was, well, the damage was related to domestic violence. So can you certify so that will show, in the past, so now that they can get housing. So, this is one of those times you're going to see a split between federally subsidized housing versus private housing, and B, what are we talking about when we say they're saying no because of DV? Like, and how do you link it to the domestic violence? And that's really helpful for the advocate to help make that connection.
Right.
The next question is, I thought if there was a police record of the abuser, they wouldn't be eligible for housing programs, so wouldn't be on the lease anyway.
So I'm sorry, what's the question?
I thought if there was a police record of the abuser, they wouldn't be eligible for housing programs, so wouldn't be on the lease anyway.
So if you're saying if the abuser has a conviction that they wouldn't be eligible for housing anyway?
I'm just reading you the question.
Great. I'm not 100% sure I understand.
Well, I mean, so if our interpretation of the question or the comment is that,
Sarah said yes, that is what she means.
Yeah.
Whatever
So, let's say, victim calls police, there is a police report, right? Maybe there are even charges filed. The perpetrator, if let's say there's a lease bifurcation or something that happens, the perpetrator then would have to apply for their own protection, or excuse me, their own status for federal housing. And yes, you're right, that would be a disqualifying thing. So that perpetrator is unlikely to qualify for federally funded housing because of that.
Right.
Which, as the questioner was thinking that how this might come up in bifurcation, and I think that would be accurate, that if it was bifurcated, and if both parties were technically eligible, and one of the parties was arrested by the police for domestic assault, it very well may make them not eligible anymore.
Right. And when I was talking about that 90-day period in which you could apply for additional housing, I was speaking specifically about the survivor or the victim and not the perpetrator.
That being said, if there ends up that there is not the police record or anything like that, and the victim chooses to go a different route to certify that they are a victim, and the landlord terminates the lease and they, separate and move on, it's certainly possible that the abuser could still retain their eligibility simply because they, who knows if the housing provider would actually find out about that. So it kind of just depends on how much government involvement there is in the violence.
Also, if law enforcement was called and the abuser was arrested, would the abuser be removed from public housing or from the ability to have public housing anyway because of the fact that they were arrested?
Right.
Yeah. I mean, yeah. I think that's fair, a fair assumption.
Okay. And then let's see. Well, somebody asked if any victim of domestic violence, no matter their housing, is covered by VAWA. Isn't this true? Nope. It only applies to federally subsidized housing is covered by the
Right.
Violence Against Women Act. It has to do with the separation of what the federal government can do versus what the state's government can do. And the federal government can't tell state government really what to do. They can give them carrots and sticks, but they can't actually make them do anything. We have a really good webinar on the separation between like federal and state and kind of what those court systems look like to help folks understand that a little bit better. And then the question was about how the statute, yep, and then there's a separate statute that exists in Minnesota that covers private housing that allows a domestic violence, stalking, or sexual assault victim to break their lease, but that's separate from the federal law that allows folks who are in private housing to be able to use that statute. So that's what we were trying to explain today, is the difference between the Minnesota statutes that apply to private housing and then the federal statutes that apply to federally subsidized housing.
That's right.
You got it.
Oh, okay. I think that's all of our questions. We've got like 10 minutes for our hypotheticals, so take it away.
All right,
Perfect.
go ahead, Amy.
What a lead in. All right, so we're going to be working with Maria on hypothetical 1. Maria has applied at public benefit apartments. So we titled it public benefit apartments here to designate to you that we are talking about federally funded housing. And it's for a 2-bedroom apartment for herself and her 16-year-old daughter. They waited for 2 years, and then after that point, Maria gets a letter denying her application because a former landlord reported apartment vacated 2 years ago damaged. Now, in reality, the apartment was damaged when her daughter's boyfriend broke 3 windows and kicked in the door after her daughter ended the relationship. At the time, Maria called the police and the boyfriend was arrested. Neither Maria nor daughter have seen him since the arrest. The lease at the apartment was terminated because of that incident, and Maria's family moved. And now she has been given a denial on her application for federally funded housing. Rachel, will VAWA help Maria?
Yeah, I mean, I think this is a perfect example of a situation where Maria could be helped by asserting her VAWA protections, even though the damage was caused by her daughter's boyfriend, not Maria's boyfriend. In this case, that doesn't matter. It can be any household member, domestic violence that was committed by any household member. And so in this case, I would recommend that Maria assert her VAWA rights, inform the public housing authority or the apartment manager that she was a victim of domestic violence or a household member was a victim of domestic violence. That is the reason that the damage was caused. There is that direct causal relationship. And hopefully by asserting that and by providing documentation should they need it. And in this case, I think, Maria called police. There is a police record out there. There might have been charges or convictions in order to back up what she's saying, or she could get, an affidavit or document signed by a domestic or sexual violence advocate in order to support her claim. And then hopefully she will be, her application will be granted.
And now, Rachel, would this be different if the building was not federally funded?
Right. So if it weren't federally funded, she wouldn't have those direct VAWA protections to help her. So yeah, that would make a big difference.
So if we're thinking about this, let me see. Let's change the analysis a little bit here. So we're going to change the facts. Let's say that the damage was actually caused, and it was reported by Maria's landlord, that the damage was caused by Maria and a friend of hers when they got drunk and partied in the apartment. Would VAWA help Maria then?
Right. So because the damage wouldn't have been a direct cause of the domestic violence, even though there may have been domestic violence occurring between her daughter and her daughter's boyfriend, because that damage wasn't directly related to it, I don't think that Maria would be able to invoke protections under VAWA.
Okay. Hypo 2.
Hypo 2, getting through it. All right, so Sarah and her boyfriend Carl moved into an apartment together with Sarah's 2 children. Neither Sarah nor Carl are eligible for public housing assistance. Not long after moving in, Carl became extremely suspicious of Sarah, stating that he believed she was having an affair with a coworker. When Sarah told him he was being ridiculous, Carl started locking Sarah in her room and threatening to hurt her children if she didn't tell him the truth. Sarah got assistance from a domestic violence advocate and started to make plans to move safely out of the apartment. So Amy, is VAWA going to help Sarah in this particular circumstance?
So the answer is it depends. You know, right now the hypo is telling us that Sarah and Carl are not eligible for public housing or for federal housing, federally funded housing. And as we've clarified on the webinar, you know, you have to be talking about federally funded housing in order for VAWA to apply. But as Raina alluded to earlier, it's possible that due to the need to move out and Sarah's separation from Carl, or perhaps her inability to get a different lease away from Carl, it's possible that she then does actually gain eligibility to apply for public housing. So it depends. But
Great.
that would be the distinction is, are we talking about whether she actually is eligible for federally funding housing? And if so, then VAWA can help. And now let's say she's not eligible for federally funded housing. Unfortunately, VAWA is not going to apply. But that being said, Minnesota law comes into play and at least can assist her in safely terminating her lease with that apartment. So working with a domestic violence advocacy program, she can follow those 3 straightforward steps that we alluded to in the earlier presentation, as well as in the handout that we've attached that walks you through what you need to show in order to terminate that lease at the end of the month. The lease would then also be terminating for Carl. And at that point, other than foregoing her security deposit, Sarah should be able to move out of her apartment safely.
Great. So I kind of want to change this up a little again. So let's say that Sarah and Carl are eligible for public assistance housing or federally funded housing assistance, and they are currently in an apartment that is federally funded. So how would that change the analysis?
Yeah, so in this situation, this would be a good opportunity for Sarah to try to bifurcate the lease. And, you know, she may have the opportunity to move to a different unit, depending on the kind of housing she was in, of course, move to an internal unit within the same building if she felt that that was safe to do so. It's certainly possible that she would have to do an external transfer. If we're talking about, you know, Section 8 voucher, she could try porting it. There are any number of ways that either a lease bifurcation can happen or an emergency transfer would be the right approach for Sarah to take.
Great.
And ultimately, I think one of the things to remember too here is the protections that VAWA or the Minnesota state laws afford to survivors of domestic violence, sexual violence, dating violence, or stalking, those really still only apply to the victim. So, you know, there is oftentimes survivors are going to ask, well, what does that mean for my partner if they're living together? And what that means is that a landlord is still going to have to go through the appropriate eviction process and procedures in order to get, let's say Carl is the person, Carl out of the apartment. So that is still a process that may end up happening, but it's something that survivors oftentimes want to know.
Perfect.
Any other questions that have come up through our discussion here, Raina, of the hypotheticals?
Sorry. I forgot to put the microphone back in front of my face. At this point, we do not have any additional questions.
It is so clear. Perfect.
We got it.
Hey, this is the most questions I think we've ever had on a webinar, so I am thrilled that people were asking them. That's fantastic, you guys.
Yeah,
Hey,
I agree. And this is complicated stuff, so please understand that, you know, you can view this webinar as many times as you want, but if an issue arises, obviously Standpoint is here to talk through those issues with us. All you have to do is give us a call. Or Amy, I think you listed a bunch of resources here that are really helpful as it relates to housing law.
And the protections, yep, that are afforded to women who've experienced those kinds of violences. Yeah, I mean, on this webinar, we have said, I think, no fewer than 10 times, this is complicated, call us, we can talk you through it. That's why we're here. You're never bothering us. So please do give us a call. And then in the meantime, you know, these are just some helpful resources. Homeline has kind of a, you know, online tutorial or I don't even know what to call it, that you can walk through to try to help figure out what your rights are. The Minnesota Coalition for Battered Women, as it relates to women experiencing domestic or dating violence, has a housing program manager. They've got a lot of great resources. And then there are also some national resources here that are listed that can also provide either advocacy or survivors with some helpful info. So I think with that, we're about done. We've got our contact information for all of you guys. You've got both Rachel and my direct dials. As I said before, if you're talking to an Amy and the person's like, I'm gonna have to talk, you're gonna send you to a different Amy for the housing stuff. You know, don't be offended. We try to triage as best we can. But please do reach out to us and share this webinar with other advocates and folks that you know that might benefit from it. We put them up on our YouTube channel. You can subscribe to our YouTube channel. I think maybe Raina's going to talk about that. So any final words, Rachel?
No, I think you did great. You're never, I mean, as we always say at all of our presentations, you are absolutely never bothering us when you call us. So if you do have something that arises and you're not sure if it's appropriate to call us, just call us. If we're not the appropriate referral, we will definitely get you to someone who may be able to answer your question.
And
thanks for your time today.
And there's never a stupid or easy question, because
No.
we love the easy questions because it makes us feel really smart, and then we feel like we did something really good today. So please always remember you can call us. Yes, and I register, subscribe to our YouTube channel. Also, if you're not on our Legal Advocates listserv, you can shoot us an email and we'll get you on that Legal Advocates listserv. New Laws is coming up. Registration opens next week. So register for New Laws and look for our next webinar, which I believe is July 17th. And that's going to be on the criminal law process, kind of as it relates to sexual assault, since that process is different than what it looks like on the domestic violence side. It takes longer, you know, all that kind of stuff. So Amy Eisner is going to be talking about the criminal law process in our next webinar. So look for registration information on that coming out on the listserv. Thank you all so very much for joining us, and we look forward to seeing y'all at New Laws and for y'all being on our next webinar in July. Thank you. Have a good rest of your day.
Thanks all.
Thank you.